ICC Pre-Trial Chamber 2 judges have thrown out appeals by Deputy Prime Minister Uhuru Kenyatta, Ambassador Francis Muthaura, Eldoret North MP William Ruto and radio journalist Joshua Arap Sang, challenging the decision to indict them. In rejecting the appeals, the Pre-Trial Chamber 2 judges disagreed with the defense teams of the accused, saying that the Ocampo 4 appeals hinged on a misconception and misreading of the Chamber's decision. The accused Ocampo 4 filed the appeal challenging Ocampo's probe into the post-election violence and the threshold of his evidence. The accused claim Ocampo failed to follow up exonerating leads and his witnesses were unreliable, use of anonymous evidence and failure by the judges to apply evidentiary principles consistent to both the defense and the prosecution witnesses. But in the ruling, the ICC judges say the defense team's arguments were based on a selective approach resulting into a misrepresentation of the confirmation of charges decision. The judges overruled the defense team, stating that there was no misrepresentation of the confirmation of charges decision as alleged by the defense teams. And on the contested witness number 8, who defense teams of Ruto and Sang claimed that he was coached, thereby unreliable, the judges ruled that the chamber holistically approached evidence evaluation as opposed to a mechanical weighing of individual pieces of evidence against each other. The court threw cold water on Uhuru Kenyatta's appeal to disassociate the November 26th meeting at State House with the Mungiki. The judges ruled that Uhuru lacked appealable grounds but rather merely disagreed with the chamber's assessment of evidence. Uhuru and Muthaura had filed an appeal claiming the chamber had erred in law and abused its discretion by using anonymous witnesses and indirect evidence from unreliable sources that required corroboration. Nonetheless, the pre-trial chamber judges ruled that it cannot be the case that a piece of evidence not considered credible makes the evidence unreliable. The dissenting judge Hans-Peter Kaul refrained from taking a decision, stating that he felt bad in principle, having issued 3 dissenting opinions on the Kenyan case. Sam Ogina, KTN Prime.